So, ladies and gentlemen, good evening. It is with deep gratitude and overwhelming pride that I welcome you all to the inaugural lecture on Voices in Arbitration. This initiative is more than just a series of lectures, it is a dream born from a belief that our region deserves a platform where ideas can flourish, where young practitioners can be inspired, and where leading voices in international arbitration can share their wisdom and experience with us. Through this program and each week, we will have the privilege of hosting a distinguished expert in arbitration. And who could be better to start the first lecture than Gary Bourne himself, one of the world's leading authorities in international arbitration, someone whose books have guided and inspired all of us in our journey of learning arbitration. Mr. Bourne is chair of International Arbitration Practice Group at Wilmer Cutler. He is the author of some of the most authoritative books in the field, including International Arbitration and Forum Selection Agreement, International Arbitration Cases and Materials, and International Arbitration Law and Practice, who we all have and studied, and many other books. He has been ranked for the past 20 years as one of the leading international arbitration practitioners. Professor Bourne has participated in more than 675 international arbitration cases, including 4 of the largest ICC arbitration and several of the most significant ad hoc arbitration in recent history. He is one of only 2 practitioners to achieve starred status for international arbitration in the Chambers Global. Chambers describes him as the world's foremost authority in international arbitrations and litigation. And I can go on and on till morning. So with this, I would love to thank Professor Gary Bourne for accepting my invitation. I know how incredibly busy Mr. Bourne is, yet he generously took the time to join us and inspire us even more. To have him with us for our inaugural lecture is not only an honor, but a moment of pride for all of us. Before we begin, ladies and gentlemen, let's introduce and welcome the Dean of the College of Law at the American University of Iraq, Baghdad, Professor Khansa, to deliver her remarks and extend her welcome to our distinguished guest. Dean Khansa, the floor is yours.
Good evening. This is Dr. Kansa Jassim, the Dean of the College of Law at the American University of Iraq, Baghdad. Professor, we are honored to welcome you as our distinguished guest lecturer today. You are one of the leading experts in your field, and we deeply appreciate your time and the insights you bring. To all legal practitioners joining us, we are privileged to have you participate and look forward to a dynamic, engaging discussion that will provide valuable perspectives and practical insights for the legal community. Thank you so much, Dr. Gary Bourne, and the floor is yours. Thank you so much.
Thank you, Dean Khansa. Just to be informed before beginning that there will be 15 minutes breaks after 1 hour of this lecture. Then we will continue the lecture. It will consist of 60 minutes of lecture, then 30 minutes of discussions and asking questions. Maybe we will open the microphones at the end of this lecture. And with no further ado, I leave the floor to Gary Bourne.
Thank you so much. And also, thanks to the American University in Baghdad, and in particular to you, Hatem, and to Dean Khansa for the very kind invitation. It's a privilege, it's an honor to be with you today. And perhaps equally importantly, thanks to all the many participants who've taken time out of what I think is probably a beautiful evening in Baghdad to listen to me. It's challenging to give the introductory lecture here, especially on the topic which I'm going to explore, multi-parte and multi-contract issues. The reason it is challenging is because that's usually a topic that gets addressed not in the introductory lecture, not the first lecture, but perhaps towards the end of the course. It is a rather detailed and technical topic that presumes a lot of previous introductory materials. But with your patience and tolerance, we will explore this topic. Moving to the next slide, we'll do it by way of first considering general principles and then considering the topics of consolidation, joinder, and intervention under both national arbitration legislation, especially the UNCITRAL model law and international commercial arbitration, but also under the very important topic of institutional arbitration rules. We'll look in particular at how one constitutes a tribunal, how one selects the arbitrators in a case where you have multiple parties. And we'll then briefly examine, if we have time, both multi-contract issues and class arbitration. Moving to the next slide, and trying also to take a step back from these details like consolidation and intervention. Arbitration, international arbitration in particular, is of course consensual. The foundation of any international arbitration is the parties' agreement. They must consent to arbitrate. Without an arbitration agreement, parties have no obligation to arbitrate, and no party has a right to demand that its counterparties arbitrate a particular dispute. Instead, it is national courts, state courts that will be the appropriate forum for resolving their disputes. In international matters, though, arbitration is often the natural or preferred means of dispute resolution. I describe it as that because of what I call the 6 E's of international arbitration. International arbitration is more expert than the alternatives. It is more expeditious and more efficient than the alternatives. It's also more even-handed and ultimately more enforceable. And that's 5 of our E's, and I'll say another word about each one of them in a moment. The 6th E, which is somewhat more recent in its origins, is that international arbitration is more electronic, as perhaps this online seminar demonstrates, than the alternatives. And again, I'll say a word about that. Why is it that international arbitration is more expert than the alternatives? It's more expert than the alternatives because the parties themselves choose the arbitrators. In a 3-person tribunal, each party typically, customarily, chooses one arbitrator. And those 2 arbitrators then together, chosen by the parties, select a presiding arbitrator. And they do so, of course, after a particular dispute has arisen. What that means is the 2 people in the world, the 2 parties, who know the most about their dispute and about their industry, and who have the greatest incentive for having a competent expert tribunal, are involved in, responsible for choosing the arbitral tribunal. And if you compare that to most national courts, where the case is assigned often randomly to a judge who typically is a judge of general jurisdiction who, bless her heart, must decide every sort of case, cases from administrative law to cases involving insurance policies to cases involving criminal law, to other sorts of disputes. And perhaps once in her life, she's had a case that is a little bit like the case that the parties present to her. And in contrast, in arbitration, the arbitral tribunal is handpicked, not randomly, not from people with general expertise, but people with specific expertise. And if you have, for example, a telecommunications joint venture dispute that involves Iraq and Kuwait or Libya or another country, you can choose an arbitral tribunal with specific experience in both that sector, in that type of agreement, joint venture agreements, and in the applicable law that may apply to the parties' agreement. Naturally, the arbitral tribunal will, without any disrespect to the national court, have much greater expertise. An arbitral tribunal also is capable of being more expeditious. That means going faster than a national court. In many national courts around the world, I won't pick any particular country, judicial proceedings can take a very long time. And naturally, in national courts, there are appellate proceedings, often multiple layers of appeals, which can, in many cases, put the parties right back in the trial court where they began. And as a consequence, judicial proceedings, even in somewhat straightforward commercial cases, can often take a very long time. In contrast, international arbitration has an incentive, a strong incentive for the arbitral tribunal to move promptly under many institutional arbitration rules, where their compensation will depend on how promptly they hear the case and decide the case. Many institutional rules as well have fast track procedures for smaller value cases. The ICC, for example, in cases of less than 5 million US dollars, has a 6-month time limit, a fast track arbitration. And many other arbitral institutions have similar approaches. Because the arbitration is fast tracked, and also importantly, because it doesn't have appeals. There's only a possibility of annulment of the award, not a full appeal, and certainly not layers of appeal. The arbitral process is almost inevitably quicker than when you take a step back and look at the entire litigation process than the litigation process would be. And because international arbitration is, at least in most cases, more expeditious, that means faster than the alternatives, it's also more efficient. It's more efficient because in law, with lawyers, time is money. And the more time that an arbitration or a litigation takes, the more clients will be required to pay their lawyers. And the more time the clients will be distracted from their real business, which is commerce and enterprise, not conducting litigations. And as a consequence, also because arbitral tribunals have expertise in the field and therefore don't need to be re-educated, arbitral proceedings are, in general, not necessarily in every case, but in general, faster and more efficient, more cost-effective than the alternatives. Importantly, in international arbitration, moving to our fourth E, the proceedings are typically more even-handed. And by that, I mean more neutral and objective. In international disputes, each party will inevitably wish to litigate a dispute on its own home turf, in its own local courts. An Iraqi party with a French or a German counterpart will naturally wish to litigate in Baghdad or Erbil or somewhere else in Iraq. The German party, on the other hand, will want to litigate in Frankfurt or Berlin, somewhere in Germany. And both of those two jurisdictions, Germany and Iraq, inevitably will be perceived, and in some cases will be, somewhat biased in favor of the local party. And as a consequence, international arbitration conducted in a neutral seat, administered by a neutral arbitral institution, is almost always more even-handed, particularly because the arbitrators have obligations of independence and impartiality and are subject to challenge procedures. And as a consequence, businesses that want a neutral, objective resolution of their dispute almost always prefer international arbitration to the risks of litigating potentially on their counterparty's home turf. International arbitration is also moving to our fifth E, more enforceable than the alternatives. It's more enforceable because of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the so-called New York Convention, which makes international arbitration agreements subject to mandatory recognition in national courts in 172 contracting states all around the world. And in addition, does the same thing with arbitral awards, makes arbitral awards subject to recognition with only limited exceptions in all 172 contracting parties to the New York Convention. And as a consequence, when parties agree to arbitrate, they know that agreement will be respected in most jurisdictions around the world, and they know that the ultimate award, the arbitral award that resolves their dispute, also will be respected. And in contrast, there's no equivalent for forum selection or choice of court clauses, and there's no equivalent for national court judgments. And as a result, international arbitration enjoys what I might call an enforceability premium as compared to the alternatives, litigation in national courts. And finally, international arbitration, in part because of the unhappy COVID-19 experience, has become more electronic. In contrast to national court proceedings, many procedural hearings, many hearings on interim measures, on disclosure disputes and the like are conducted just like this lecture online, which means in an international context, very significant savings, both in transportation, accommodation, but also importantly, the time of lawyers and even more importantly, clients. And so as a consequence, parties almost always include international arbitration clauses, typically institutional clauses, in their arbitration agreements. And now moving to the slide that you can see in front of you, the classic paradigm of these arbitration agreements that they agree to is a bipartite. That means two parties to the arbitration agreement. A concludes a purchase and sale contract with B, and in that contract, there's an arbitration clause. That arbitration then proceeds in a very usual way. A appoints a co-arbitrator, B also appoints a co-arbitrator. Together, those two co-arbitrators select a presiding arbitrator. And then the claimant asserts claims against the respondent, possibly counterclaims in response. And you have a two-party arbitration that continues throughout the life of the process. And it, in many ways, is a relatively straightforward and clean process. And in the majority of cases, more than 50% of all cases, that is in fact the constellation, the arrangement of parties that one sees. But in practice, one also sees other constellations, which is today the main topic of our discussion. In practice, many contracts don't have just two parties. They have multiple parties. They may have 3, 5, 7 parties. And as a consequence, the disputes that arise out of these contracts also can have multiple parties. Indeed, and you can see this on the slide, not long ago, the ICC reported that 30%, actually 31% of all new cases filed with it involved multiple parties. That means not just two parties. And in some of those cases, there were up to 5 and indeed even more parties, sometimes a dozen, a couple dozen parties, which can lead to very significant procedural complexities. The ICC's figures from 2020 are replicated in subsequent years. You can see on the next slide the 2020 figures, and I can assure you that in subsequent years, if we move to the next slide as well, subsequent years the figures were similar. Moving to the next slide, one might ask the question, well, if you have a multi-party case, if we just move to the next slide, if you have a multi-party case, do you in fact have a valid arbitration agreement? Can 3 or 4 or 5 parties agree to arbitrate with each other in the way that just 2 parties can? The answer to that is emphatically yes. Both the New York Convention and also national arbitration legislation, the Utzitral model law, for example, very clearly provide that multi-party arbitration agreements like bipartite two-party arbitration agreements are fully valid and enforceable in all leading arbitral institutions, the ICC, the LCIA, DIAC, Arbitrate AD in your region will administer arbitrations involving multiple parties. However, importantly, those arbitrations, not with two, but with three, four, five, some multiple number of parties, involve very significant procedural issues that don't arise in a two-party arbitration. And in particular, they involve questions first of consolidation, joinder, and intervention. They also involve questions about how you choose the arbitral tribunal, and they can present significant procedural issues once the tribunal has been constituted. They can present issues about what is the order of submissions, or even mundane issues such as where do the parties sit in the hearing room? Does party A sit with party B or with party C? And I'll come and address some of these questions shortly. Moving to our next slide, and a little bit by way of definition, there are three main initial questions that can arise if you have multiple parties to a dispute. These are consolidation, which addresses the question whether two or more potentially separate arbitrations, for example, an arbitration between A and B and another arbitration between B and C, can be consolidated into a single arbitration involving A, B, and C. And we'll look at these questions of consolidation, where there would be a single arbitral proceeding and a single arbitral award in just a moment. Secondly, there are questions of joinder, which are closely related. Joinder involves a situation where you have an arbitration between A and B, and a third party, C or D, wants to try and join that arbitration, or one of those two parties, A or B, wants to join the new party, C or D, into the arbitration. And we'll look briefly at whether or not A or B have the right to force C or D to join an existing arbitration. And finally, we'll look at intervention, which is the mirror image of joinder. Can the third party, in my example C, require A and B to permit it to join the arbitration and to participate in the proceedings? Moving to the next slide, and still by way of general principles and definitions, multi-contract arbitrations are similar to multiple party arbitrations, but with a difference. Often commercial transactions in the contemporary world involve not just one contract, but multiple contracts. You might have a joint venture agreement coupled with a shareholders agreement, coupled with some ancillary agreements. You might have a framework agreement combined with multiple purchase and sale contracts that implement that framework agreement. A multi-contract arbitration is an arbitration that arises not under just one contract, which is the classic paradigm, the usual historical way that arbitrations would proceed, but instead it involves multiple different contracts, all of those various contracts, the joint venture contract, the shareholders agreement, or alternatively, multiple different purchase and sale contracts. And these two can present complicated procedural issues that we'll look at very briefly. Moving to the next slide, the topics that we've all addressed, consolidation, joinder, intervention, multi-contract issues, all arise in national court litigation. And there are fairly straightforward solutions in national courts to dealing with these questions. In most national courts, based on notions of what's fair and what's efficient, parties can consolidate two or three different court cases into a single case, where related disputes between the same or overlapping parties are being heard in different court cases. They can all be consolidated into a single proceeding before a single judge with a single judgment deciding all of the parties' rights. And that is often seen as more efficient. Instead of having to go to 5 different hearings with 5 different judges with potentially different outcomes, you have a single proceeding before a single judge with a single consistent outcome in all cases. In consolidation, both of multiple parties, but also multiple contracts is generally fairly straightforward. Moving to the next slide, there can be obvious savings of legal fees, arbitrators' fees, witnesses' time, and the like, if you have in arbitration a consolidated arbitration rather than multiple separate arbitrations. It also eliminates, very importantly, the risk of inconsistent results. If you have two arbitrations that are closely related, one between A and B, the other between B and C, and the two arbitral tribunals, being different, interpret the contract differently, you might get profoundly unfair results where B loses to A because the contract's interpreted in one way, but then it loses to C because the contract's interpreted in the opposite way, whereas it would have prevailed if there was a consistent view. And as a consequence, most businesses, I think most lawyers as well, believe that consolidation as well as joinder and intervention in general makes sense. The possibility of having this is important. Skipping over the next slide and moving to slide 12, there can be disadvantages to consolidation. Some parties may oppose consolidation because they want the potential for inconsistent results. Other parties may, because they have only a small role in one dispute, not want to be party to a long, complicated arbitration with lots of other issues. And as a consequence, consolidation can't be an automatic decision. It requires some exercise of discretion. But as a general principle, the possibility of consolidating different arbitrations or allowing new parties to intervene or join in an existing arbitration makes sense. It obviously, though, moving to slide 15, it obviously creates issues with respect to what is the basis for these things? How is it that two arbitrations can be consolidated? How is it that a third party can join into an arbitration? And equally, how is it that one addresses the difficulties of constituting an arbitral tribunal? I'll mention these in a little more detail in a few moments, but these can be particularly challenging if you have multiple parties, each of whom wants to appoint an arbitrator on its own. There are also issues of confidentiality. Some businesses choose to arbitrate their disputes because they want those disputes and their resolution to be confidential, to be private, not to be a matter of public record. And if you consolidate different arbitrations or permit third parties to join, there's at least a potential risk of a loss of confidentiality of the proceedings. Despite all of these challenges, both institutional arbitration rules on the one hand and national arbitration legislation on the other have in recent years in particular been drafted to permit a significant measure of consolidation on the one hand and also joinder and intervention, as well as the possibility of multi-contract arbitrations. Importantly, all of these rules and all of these national arbitration statutes are guided by that fundamental principle of international arbitration that I referred to previously, namely consent. The basic foundational principle for each one of these procedural possibilities is the parties must have agreed to it. Their agreement must permit consolidation, must permit joinder, must permit multi-contract arbitration. And if it does so, those procedural devices will be permitted. If it does not do so, they will not be permitted. There are a couple exceptions to this, which we'll look at in just a moment, but the basic rule across almost all institutional rules and all national arbitration legislation is that the party's will, the party's consent, is the guiding figure. Let's move to the next slide and begin to speak both about national law, but also national arbitration legislation, but also the New York Convention. And let's start on the next slide, slide 17, with the New York Convention. Unsurprisingly, drafted back in 1958, the New York Convention doesn't use the words consolidation, joinder, or intervention. It doesn't have any provision that specifically addresses any one of these topics. Instead, the question of the status of consolidation or joinder or intervention is addressed by the general terms of the New York Convention, and in particular, Article 2.1, which you can see excerpted on the slide. And what Article 2.1 does, both in this context and other contexts, is make international arbitration agreements presumptively valid and enforceable as a matter of mandatory international law in virtually all cases. And you can see the language there on the slide. Each contracting state shall recognize an agreement in writing under which the parties undertake to submit to arbitration their differences. And so basically what the New York Convention does is gives effect to the parties' agreement, including an agreement either to permit consolidation or joinder, or alternatively, the opposite agreement, an agreement to exclude the possibility of consolidation and joinder. Whatever it is that the parties have agreed, the New York Convention requires that it be given effect. The UNCITRAL model law, moving to the next slide, as a representation of national arbitration legislation in many jurisdictions, is very similar in this respect to the New York Convention. It also doesn't use the words consolidation, joinder, or intervention, and it also only has a general provision in Article 8.1, you can see it on the bottom of the slide, to the same effect as the New York Convention, to the same effect as Article 2.1 of the New York Convention. Whatever it is that the parties have agreed to, that shall be given effect. And if we move to slide 20, the basic requirement of both the New York Convention and also the UNCITRAL model law is to give effect to all of the material terms, the important terms of the parties' arbitration agreements. And that, for example, if the parties agree to arbitrate in Baghdad in Arabic, the arbitral tribunal can't seat the arbitration instead in Damascus and conduct the arbitration in French. The selection of the arbitral seat, the selection of the language of the arbitration are material, important elements of the arbitration agreement, and they are required to be given effect by both Article 2.1 of the New York Convention and also Articles 7 and 8 of the UNCITRAL model law. Equally, consolidation and joinder, the possibility to consolidate or not to consolidate, and to join or not to join in an arbitration, are material elements of an arbitration agreement. And so when parties have agreed either one way or the other about these various topics, consolidation, joinder, and intervention, both the New York Convention and national arbitration legislation, the UNCITRAL model law, require that they be given effect. Moving to the next slide, we'll see that many institutional arbitration rules, I give as examples here, but this is a non-exhaustive list, the ICC rules, the Swiss international rules, the Singapore International Arbitration Center rules, all of these institutional rules contain provisions, unlike the convention and unlike the model law, that deal quite specifically and comprehensively with the topics of consolidation and joinder. And what's important is that taken together, those rules and the New York Convention and the model law provide a very workable method in many international cases for either consolidating separate arbitrations or alternatively for allowing joinder or intervention of third parties. Moving to the next slide, most national arbitration legislation, like the model law, does not specifically address the questions of consolidation, joinder, or intervention. There's nothing in any of the laws you can see on the slide, the Swiss, the US, the French, the Chinese, Japanese arbitration statutes that even uses the word consolidation or joinder or intervention, and there are no provisions there that specifically address the topics. Moving to the next slide, though, there are some exceptions to this rule. And for arbitrations seated in, for example, New Zealand, Australia, Singapore, there are specific statutory provisions that will deal with joinder consolidation and intervention. And as a consequence, importantly, where the arbitration is seated is quite important to whether or not consolidation, joinder, or intervention may be permitted, and if so, on what terms. Moving to the next slide. Some of these statutes, and the British Columbia statute, which you can see on the slide, is a good example, specifically provide that courts in the arbitral seat have the power independently to order consolidation and intervention or joinder. And you can see the language there, section 2701 on the slide. The local court, the Supreme Court, if the arbitral seat is in British Columbia, can order consolidation if, importantly, if the parties have agreed to consolidation. And then if we move to the next slide, other national statutes, New Zealand, Australia, allow the same thing, but they give the power to the arbitral tribunal. So an arbitral tribunal could order consolidation. Note that that can be complicated because you might have two different arbitral tribunals, and there would be a question as to which of the two. Typically, statutes provide the earlier constituted of the two is allowed to consolidate the other arbitration into an existing arbitration. Moving to the next slide, slide 26. And you've already seen this, I think, briefly on the slide, and you can see on the previous slides, and I think you can see some examples here. Essential in all these statutory cases is that parties can consolidate arbitrations only where there has been a prior agreement upon consolidation. An arbitral tribunal and a national court has no power to consolidate arbitrations or to allow joinder and intervention unless that's what the parties have agreed. And we're going to look at a moment at what might constitute an agreement for consolidation, joinder, or intervention. But the essential point is you can only do these things, consolidate, join, or intervene, where the parties' agreement provides for that. And when it does provide for that, it is mandatory. You have to have a right to be able to consolidate, join, or intervene if that's what the parties' arbitration agreement has said. And this is different, you will note. This is different than in national courts, where consolidation, joinder, and intervention can happen as a matter of right, simply as a question of convenience or what's fair and equitable in the circumstances. You don't need the parties' consent. Moving to the next slide, and we can skip over those various slides until we get to slide 33. Basically, the slides we skipped over explain the position in the United States, which through the U.S. arbitration statute and the courts interpreting it, provides the same result as what one sees in the UNCITRAL model law. You can consolidate, join, or intervene where the parties have so agreed, but not where they haven't so agreed. Note that there are some exceptions, and we're going to look at these very briefly, to the rule that I've just described. There are a couple national arbitration statutes that permit arbitrations to be consolidated even without the parties' affirmative agreement. And if you see on the slide, the Dutch, the Netherlands Code of Civil Procedure allows something to this effect. Even if the parties haven't agreed upon consolidation, the local court, if it is efficient, has the authority to do so. If we move to the next slide, 35, the consolidation is effectively the default rule. Even if the parties haven't agreed that this is possible, the court has the power to consolidate different arbitrations. Parties can exclude this. It's not a mandatory rule, but if they simply haven't addressed the question, then consolidation is possible. Moving to the next slide. The same thing is true in New Zealand and also in the United States. We can see that on slide 37 and 38. There's one very unusual exception on slide 39. In one of the US states, Massachusetts, even if the parties try to exclude consolidation, it is nonetheless mandatorily available in the interest of efficiency. Note that that is a very unusual approach, and it's not one that's followed either by the New York Convention or the UNCITRAL model law or any of the other statutes that we have looked at. Moving to the next slide, and I realize I'm giving you a lot of information here. It's force feeding. Let's look at the nature of the agreement that's required for consolidation or intervention. If the basic rule is parties can consolidate in arbitration, or there can be joinder or intervention in the arbitration, if they've agreed upon that, what constitutes an agreement? In many cases, parties' arbitration agreements don't really address the issue. If they use a standard institutional arbitration clause or the UNCITRAL model arbitration clause, it doesn't mention any of these things, consolidation or joinder. And many ad hoc clauses also don't address these topics at all. There's some exceptions. For example, if we move to the next slide, slide 41, there are some exceptions. You can draft a bespoke clause like the one that you see on the current slide that provides specifically for how arbitrations might be consolidated. And for this, if practitioners that are on the call are interested, this is the type of clause that can be included in a contract with an arbitration clause that would, where you have multiple parties, that would permit consolidation in certain circumstances. And if we move to the next slide, there are other examples that include such things as the timing of requests for consolidation and the like. And the same thing on slides 43 and 44. All of these are examples of how parties might draft themselves and put into their contract, into their arbitration clause specifically, provisions on consolidation. Note that virtually never happens. You virtually never see contracts that have this kind of detailed procedural provisions regarding consolidation, or for that matter, other things. Often what parties do instead is agree to institutional arbitration that has consolidation provisions in it. And that's usually a wise choice on the part of parties. I think it's very difficult, although I've tried to give you some model consolidation language. I think it's very difficult to prescribe in advance a procedural code for all the types of eventualities, all the types of circumstances that might arise in the future, and how you might want to or not want to consolidate. But if you do have a clause like this, a model consolidation clause, then going back to what we just discussed about the New York Convention, the UNCITRAL model law, other national arbitration legislation, that clause will be given effect. And the arbitral tribunal will have the authority to consolidate different arbitrations. Moving to the next slide. Historically, and then to slide 45, please. Historically, most institutional arbitration rules were silent, and in many cases today still are silent about these issues, consolidation, intervention, and joinder. That has changed very much, though, in the last 10, 15 years. And now most leading arbitral institutions, not all arbitral institutions, but leading arbitral institutions have provisions that have been tested and that expressly authorize both consolidation and joinder or intervention, but subject to particular sets of rules. Moving to slide 47. Where institutional arbitration rules have those provisions, then just like the model consolidation clause we looked at, they will be given effect. The New York Convention, national arbitration legislation will give effect to the parties' agreement on how to consolidate, when to consolidate, and the like. Just before we look in very briefly at what these institutional rules provide in practice, let me deal with one other situation involving the question, have the parties agreed to consolidate or not? So far, we've looked at express agreements to consolidate, the model consolidation clause that we looked at together, and then the institutional arbitration rules, which we both looked at and will look at in a couple moments. But sometimes you can also imply an obligation or an agreement to consolidate, even though the arbitration agreement doesn't say so specifically. And how might that happen? Would, for example, if you have a three-party agreement, A, B, and C enter into a contract, and the contract has an arbitration clause in it, and it doesn't say anything about arbitration. I'm sorry, it doesn't say anything about consolidation, and it doesn't refer to institutional rules. It's an ad hoc agreement, and it therefore doesn't say anything, doesn't have any institutional rules providing for consolidation. Could nonetheless, if A starts an arbitration against B, and then B starts a related arbitration against C, could those two arbitrations, A versus B and B versus C, be consolidated into a single arbitration? There's a quite substantial argument there that they could be, because the parties, by agreeing to a single arbitration clause with a single arbitral mechanism, impliedly consented to arbitrate their disputes. And if we move to the next slides, you'll see some examples where exactly that conclusion on slide 48, exactly that conclusion has been reached, and then again, slide 49, by national courts in some circumstances. When multiple parties agree to the same arbitration clause in the same contract, they have impliedly agreed both to consolidation of the arbitrations, but also the possibility of joinder and intervention. Somewhat more complicated. Suppose you have two parallel agreements, two purchase and sale contracts between the same parties, A, B, and C, and then on the other hand, a second contract between the same parties. And those two contracts have identical arbitration clauses, exactly the same arbitration clause in each one. Can you consolidate arbitrations under one of those contracts with an arbitration under the other contract? Arguably, you could. There's not any significant national court authority on this, but the better view probably is when the same parties enter into identical arbitration clauses with very closely related contracts, they impliedly consent to the possibility of consolidation and also joinder and intervention. Let's move to slide 53, where you can see, in response to the request from one of the attendees for scientific material about this, and the slides can certainly be distributed to those who wish at the end of this lecture. You can see examples of additional cases that address the question of when and how consolidation might be implied. And we can see as well on slide 55 examples of arbitral tribunals addressing the same thing. Very quickly on slide 58, because we only have now 5 minutes or so before we take our break, there are other cases where it's quite unlikely that parties could be held to have impliedly agreed to consolidate. You can see, for example, on this slide, if parties conclude our contracts with different arbitration provisions, one with the ICC rules, another with the Singapore International Arbitration Center rules or Arbitrate AD rules, then it is highly unlikely that there would be any agreement to consolidate. And indeed, those institutional rules would almost certainly forbid consolidation. And you can see an example of that on slide 59. If we could jump ahead, please, to slide 69, I'd like to turn from ad hoc arbitrations and national law to institutional rules. Whereas I mentioned previously, many leading arbitral institutions these days have institutional rules that provide specifically for the possibility of consolidation and joinder. These rules change over time. So what's in one version of these rules or in one institution's rules may very well be different from that in other institutions or under different versions of the same institution's rules. And therefore, what you need to do in every case is to look very closely at the applicable institutional rules, because they're quite technical and quite detailed in how they address the questions of consolidation and joinder. Let's start on slide 70 with the UNCITRAL rules, which are widely used for ad hoc arbitrations. Those rules do not, either in their initial 1985 version, their original 1976 version, or in the revised 2010 version, address the issue of consolidation. There's nothing in them about consolidation or joinder and intervention. There was discussion about including quite detailed provisions in those rules, but the only thing that was added is in Article 17.5, which you can see on the current slide. And it permits, and I'll read it for you, the arbitral tribunal may, at the request of one of the parties, allow one or more third parties to be joined in the arbitration as a party, provided such person is a party to the arbitration agreement, unless doing that would cause prejudice. So essentially, this addresses an example that we discussed previously. You have a contract between A, B, and C. A starts an arbitration against B, but not against C. C wants to join that arbitration. It thinks the arbitration may affect its rights, and therefore it applies to the arbitral tribunal. Let us join the arbitration. The arbitral tribunal has the power under Article 17A to permit that. And indeed, it has the power to permit that even if A, and maybe even if A and B, object to it. C has that right by virtue of the parties having agreed to the UNCITRAL rules. Note that if D, who is not a party to the agreement between A, B, and C, wants to join, that's not good enough. D has to be a party to the arbitration agreement, which in our example, it wasn't. So D and other third parties who are not party to the arbitration agreement have no right to join into the arbitration between A and B, or alternatively between A, B, and C. Moving to slide 72 and just wrapping up on institutional arbitration rules, there has been significant evolution, which in your own time you can see on the slides, in the ICC rules over the years. The 1998 rules, which are quite out of date at this point, provided for very limited consolidation, which we don't need to examine now because it is out of date. What's important is on the next slide, slide 74, the revised 2021 ICC rules have very detailed provisions that deal with both consolidation and also joinder, as well as multi-contracts. Joinders in Article 7, consolidation, Article 10, and multi-contract arbitration, Article 9. I'll just take you through it very quickly. In general, under Article 7, an additional party can join an existing ICC arbitration if something called a request for joinder is filed by an existing party. So take our ABC example. If A and B have an arbitration and A wants to join C, it can do so, but only subject to the provisions of these rules. And I should also note the ICC rules permit specifically in Article 9 of multi-contract arbitrations. You can have an arbitration that involves disputes under multiple contracts. In all these cases, you need to look, and if we flip through the subsequent slides, you need to look quite carefully at the technical requirements for when consolidation and joinder are permitted. Importantly, the concept of compatible arbitration agreements is key in this inquiry. You cannot consolidate arbitrations unless the arbitration agreements in those different contracts that produce the arbitrations are what's called compatible. That means they need to be either identical or at least not inconsistent in some way. And so if you have a clause that provides for ICC arbitration with 3 arbitrators, language Arabic, seated in Baghdad, you can consolidate that with another arbitration clause that provides for the same things, or even with an arbitration clause that provides without the number of arbitrators for an arbitration ICC Arabic Baghdad seat, because the ICC can always choose 3 arbitrators. And with that, we have in very short order prepared ourselves for a 15-minute break, and we'll come back and address questions when we have concluded. Thank you very much for that, and I look forward to seeing you quite shortly.
Thank you, Professor Gary. See you in 15 minutes.
Okay.
Welcome back, Professor Gary.
Thank you for having me again.
It's a pleasure always. So we will begin the discussions and we will open the microphones for all participants who wish to ask Professor Gary a certain questions. But may I start? Personally, I have one question regarding multi-contract. What are, as an arbitrator, what are the challenges? How you consider consolidating two contracts or more than two contracts between the same parties in one single request of arbitration?
So there are different avenues. It's a great question. There are different avenues, different paths that one can take to produce a multi-contract arbitration. One possibility, and many institutional rules permit this, is file a request for arbitration under 2 or 3 contracts, asserting that all those contracts are governed or subject to the same arbitration agreement, or that although they're different arbitration agreements, they're identical in their terms and they contemplate a consolidated arbitration. So the claimant starts an arbitration under, say, 3 closely related purchase and sale contracts, one for the delivery of 100 tractors, the other for delivery of 50 tractors, another for delivery of another 25 tractors. And they all have an ICC arbitration clause, Arabic language, Baghdad seat, 3 arbitrators. And you file a request for arbitration under the SEC rules, setting forth all 3 arbitration agreements, saying either they're the same arbitration agreement, which probably isn't true because they're in 3 different contracts, or that they are identical in their terms and therefore can be included pursuant to Article 9 of the ICC rules in a single arbitration. And that's what the parties intended. This is consistent with their intent. If you're the arbitrator, then if in some cases the respondent won't object, and the arbitrator can then conduct the arbitration, and in many instances it really is more efficient than if you had 3 separate arbitrations. The contracts may be essentially identical, the purchase sale contracts, just different numbers of tractors, the same reps and warranties, same issues about purchase price. The factual disputes may be identical. Somebody says the tractors don't work properly. That's true of all 175 tractors, or that payment wasn't made. If there are discrete factual issues, you just deal with them the way that you would deal with multiple claims under a single contract. So that's one fairly straightforward way that you could deal with this issue. Another way is the classic case of consolidation. The claimant brings a claim under the contract for 100 tractors, and then the respondent brings a separate arbitration under the other 2 arbitration agreements, under the contracts for 50 and 25 tractors. And the question is, can you consolidate those 2 separate arbitrations, 100 tractors with the 75 tractors? And under the ICC rules, indeed you can, and you would work your way through the technical provisions that we didn't have time to study in detail, but effectively they would permit consolidation because you have the same parties. They've all agreed to an arbitration agreement. The arbitration agreements are compatible in those 2 contracts, as I've already described. The hypothetical is that they're identical. And as a consequence, even though 2 separate arbitrations had been started, then those could be consolidated into a single arbitration with a single arbitral tribunal, producing ultimately a single arbitral award. And that would be true even if, for example, the party that started the first arbitration objected. It might, for whatever reason, not want a consolidated arbitration, but the ICC would have the authority to consolidate the 2 arbitrations if it thought that that was what was most appropriate and most efficient based upon the party's agreement to the ICC rules, which gives the authority to the institution. And again, in those circumstances, the arbitral tribunal would simply conduct the case in the same way as if a single arbitration had been commenced. Note that you could have some circumstances there where the question of constituting the tribunal gets complicated. For example, the tribunal might already be selected in the first arbitration. And then in the second arbitration, assume the respondent selects a different co-arbitrator than in the first arbitration. And in a sense, you then couldn't, without doing something else, consolidate the two arbitrations because you'd have different tribunals. You couldn't have one tribunal since you've already got three arbitrators in one case, and then in the other case, you're going to have at least one different arbitrator. In those circumstances, both the ICC rules, but other institutional rules give the institution the power to choose which tribunal and which method of constituting the tribunal is permitted. And in my example here that we're discussing, it's fairly easy. You simply use the first tribunal, and both parties have participated equally in constituting the tribunal. Things get a lot more complicated if you have multiple parties. My example is multiple contracts, but the same parties. If you have multiple parties, you need to have a mechanism to choose an arbitral tribunal that treats them all equally. And if, for example, you have four different parties, they can't all choose an arbitrator. What happens in those circumstances is that the institution will choose all of the members of the tribunal. And that will apply in the single consolidated arbitration for all of the parties. That denies parties the right that they would otherwise have to select a co-arbitrator, but that's a consequence of their having agreed to the ICC rules, which provide for that possibility.
Thank you so much for the detailed answer, Professor Gary. You also mentioned the identical arbitration agreement and compatible arbitration agreement. Is there a difference between the two?
There is. I mean, so, and I tried very briefly at the end of the lecture to outline that, but let me say it in a little more detail. An arbitration agreement would be identical if it had exactly the same wording. For example, all disputes arising out of this contract shall be finally resolved by ICC arbitration conducted with the seat in Baghdad, Iraq. In the Arabic language, there shall be 3 arbitrators. And then the second contract has exactly those words, exactly what I just said. Those are identical. They're not the same arbitration clause because they're in different contracts. They're identical words, but they're not the same. You have the same arbitration clause when in the first contract you have multiple parties who have all agreed to the same clause. But technically, the very same words in a different contract are a different arbitration clause. It's just, it has identical language. Compatible is a different concept. Compatible is exactly what I said before. All disputes arising out of this contract shall be finally resolved by ICC arbitration conducted with the seat in Baghdad in the Arabic language, and nothing about the number of arbitrators. And so the clauses are different. One clause chooses 3 arbitrators. The other clause is silent. Those are compatible because the second clause can be administered in a way that is identical to the first clause. How does that happen? That happens by the ICC choosing 3 arbitrators, even though they would otherwise have the discretion to choose 1 arbitrator. The ICC chooses 3 arbitrators in the second arbitration, therefore making that arbitration compatible with the first arbitration. What would be an example of clauses that are incompatible? An example would be the first contract is just what we described. ICC rules, Baghdad seat, Arabic language, 3 arbitrators. The second clause is SIC arbitration, English language, Damascus seat, 5 arbitrators. They are incompatible because you can't conduct one arbitration under both of those two sets of rules. Those two sets of rules provide for different procedures that cannot be reconciled. And so compatible is where the clauses are similar but not identical and can be administered in a way that is the same. Another example would be all disputes arising out of this contract shall be resolved finally in accordance with the ICC rules in an arbitration conducted in Baghdad. Nothing about the language before three arbitrators. And in that circumstance, it is for the arbitral tribunal to decide the language of the arbitration. The clause is compatible because they can choose Arabic as the language, thus being consistent with the clause that we discussed previously, where Arabic is expressly chosen as a language.
Perfect. Crystal clear. Thank you so much. Now we will hear from the audience. Ustada Rana.
Good morning, Professor. I
Good-
really
good
appreciate your
afternoon.
time. Could you provide a reference that supports the principle of not allowing joinder of arbitration claims?
So I wouldn't refer to that concept of a prohibition on joinder of arbitration claims. I think the principle that I would refer to would be arbitrations and claims in arbitrations may be joined when that's what the parties have agreed, but cannot be joined if the parties have not agreed to that. And the reference would be our old friends, Article 2 of the New York Convention, Articles 7 and 8 of the UNCITRAL Model Law, as well as the basic principle of consent as the foundation for arbitration.
Thank you
Perfect.
so much, Professor.
Now moving to Mr. Mahmoud.
Good afternoon, Professor Iqbal and Gary, and good evening for Mr. Hatem, my dear friend, and Professor Khansa. I'm really thankful for this opportunity from the American University in Iraq, and really appreciate it so much for opening this discussion and make this opportunity for us to meet you.
Okay.
My
Thank you.
question is, according to our law in Egypt, the judge cannot handle a case until the fourth degree of relationship or relativity to the arbitrators or the disputes. According to the ICC rules and according to the arbitration rules, how can I guarantee that this arbitrator is not a relative to the arbitrators or even have a friendship? According to binding the sides not to have a side each on side, and how can we have this confidentiality to know if there is no a past relationship or anything that can make a binding decision according to these arbitrators? And thank you for this opportunity.
That's a great question, which applies not just in multi-party and multi-contract arbitrations, but in any arbitration, including two-party single contract arbitrations. So in many countries like Egypt, there are national laws that regulate how the judiciary, the courts, will address conflicts of interest. And they address things like relations with the parties' relations with counsel. They address also prior law clerks who might have worked for the judge and then gone into prior practice, and prior decisions by the court involving the same parties. Those laws differ from country to country. In principle, those rules do not apply to international arbitrations, including international arbitrations that are seated in that country. So, for example, an arbitration seated in Egypt, in principle, the rules governing the Egyptian judiciary would not be automatically applicable in the arbitration. The parties might agree that those rules should apply, but in most cases, of course, they don't do so. What then substitutes for or is applicable if those national law rules regarding the judge's conflicts of interest don't apply. The ICC rules have in them requirements that the arbitrators be what's called independent and impartial on the one hand, and also that they make disclosures to the parties, both when they're nominated and then subsequently throughout the case, of any circumstances that might potentially give rise to doubts as to their independence and impartiality. The concepts of impartiality and independence are defined in commentary to the ICC rules, and they're defined rather broadly. And arbitrators are required, when they're nominated and before they accept appointment, to disclose any matters that might cause concerns about those things, independence and impartiality. Independence and impartiality are elaborated in something called the IBA Guidelines on Conflicts of Interest in International Arbitration, IBA being the International Bar Association. Those rules are available on the IBA website, and they explain in a lot more detail than we have time to do right now what the concepts of independence and impartiality mean. And they also explain what items must be disclosed by arbitrators. They have what's called a traffic light system. That means a red list, actually two red lists, an orange list and a green list, which require, if items are on the red list, for example, the proposed arbitrator is a party to the arbitration or a close relative of a party to the arbitration. It's on the red list. That means that both must be disclosed, but is a prohibition. That arbitrator cannot be an arbitrator in this proceeding. There is an orange list, which is very long. It's probably, including subparts, 50 items long. And it includes all sorts of things, such as relationships, friendships, past appointments by the parties, past appointments by the arbitrators, by the council, and the like. And then there's a very short green list, which are items that don't need to be disclosed. And so what you can do is insist that the arbitrators make disclosures in accordance with the IBA guidelines. And if you wish, although it's a delicate question, you can also ask that the arbitrators make further disclosures, for example, in accordance with the Egyptian judicial procedures. The arbitrators may or may not do that. And there's a challenge procedure where if an arbitrator makes a disclosure of certain things, or if you find out something which she or he hasn't disclosed, you can use as a basis to challenge in the ICC or ultimately in a national court.
Thank you so much, Professor Byrne.
Of course, thank you for the question. I think
Thank
we have
you.
time maybe for one more.
Yeah, we do. Our last question goes to Ustada Hana.
Good evening for everyone. Thanks, Mr. Hatem and Prof. Khansa for this lecture, and glad to join Prof. Gary the first time in this lecture. I'm Hana Shallouf from Libya, law student and interest in arbitration field. I will try my best to ask my question in English because it's the first time to join arbitration in English. So try to help me, Mr. Hatem or Prof. Khansa, if my question not clear. My question is, our Libyan arbitration law actually doesn't mention to joining or addition parties to disputes resolved by arbitration. So how we can resort to joining or adding parties in this case if it's really necessary for a party to prove their right in the dispute? Because our law of arbitration never or add or mention to this. So please, I need your answer, and I hope that my question clear. Thank you.
The question is very clear. Congratulations on your first English question, at least in an arbitration context with I think 195 people listening. So I won't give my answer in Arabic. I'll give it in English. So Libya is not at all unusual, as you'll recall, at least in this respect. As you'll recall from the slides that we looked at previously, neither the UNCITRAL model law nor French arbitration law, Swiss arbitration law, most other national arbitration statutes mention consolidation, joinder, or intervention, and have nothing specific about any of those topics. So Libya is not at all unusual in this respect. The easiest way to provide for the possibility of consolidation is to agree to institutional arbitration rules in your arbitration clause. That then would be given effect, that choice of, say, ICC or Singapore International Arbitration Center or Arbitrate AD rules would be given full effect by Libyan law. Libyan law would give effect to institutional arbitration clauses, and those rules have in them quite complicated but quite effective mechanisms for consolidation. They allow consolidation of multiple arbitrations. You need to work through exactly what arbitrations can and can't be consolidated, but there is a definite possibility of consolidating. It also allows for joinder and intervention of other parties. Of course, those parties have to be parties to the arbitration agreement. And if you're trying to join a third party who's not a party to the arbitration agreement, you can't do that. You can't do that under Libyan law, I assume. You certainly can't do that under UNCITRAL, US, English, French, Swiss law. If there's a third party who has not joined, who is not a party to the arbitration agreement, that party can't be joined. It can't intervene. It might do so, unusually, if both it and all the existing parties to the arbitration agreed. You can have a subsequent agreement effectively amending the arbitration agreement, but absent agreement by the parties, then under no national law, except possibly that strange Massachusetts statute that we looked at, under no national law and under the New York Convention, can you join or allow intervention of a non-party into the arbitration. One final possibility, if you haven't taken my advice about using institutional arbitration clauses and instead have an ad hoc clause with an arbitration seated in Libya, and you want to join a third party or to consolidate two arbitrations, then I think the best model that you could follow would be the US model, which is where courts have taken the basic requirement that they give effect to arbitration agreements and say that the parties' arbitration agreement, in your case, contemplates, not expressly but impliedly, the possibility of consolidation or joinder. And I mean, concretely, you have a contract and an arbitration agreement with three parties, A, B, and C. A starts an arbitration against B, but not against C. You want to join C into the arbitration. There are two ways you could do that. You could either ask the arbitral tribunal in the A-B arbitration to do that, but that would be difficult because C would not have participated in constituting the arbitral tribunal and might therefore object, saying, I don't want to be joined into this arbitration where the other two parties chose the arbitral tribunal, but I didn't. And that would be a pretty good objection, both in front of the arbitral tribunal and I would expect in front of most national courts, including a Libyan court. Another possibility would be to go to a Libyan court very early in the proceedings before a tribunal had been constituted and try to join C at that point, telling the Libyan court that it should order arbitration consistently with the parties' arbitration agreement, which you would say contemplates consolidation or joinder and intervention. There is not, I would imagine, much authority on that in Libya. There's not much authority in most countries, but relying on the basic principle that the parties' arbitration agreement, which you would say includes consolidation, joinder, and intervention, should be given effect, you could ask the court to do that. And with that, I think we've hopefully
Thank you so
answered the
much.
question.
Thank you
Yeah.
so much for your
Prof.
clear answer, and thank you for Mr. Hatem for his effort, and Prof. Khansa. Thank you so much.
Pleasure, Mr. Hana. Professor Gary, it's a rare moment to have you. So may I request one last question from the audience? One last question.
Yes, of course.
Thank you so much. It's Professor Asr Harb. He is working in the Egyptian State Council. Please, Professor, proceed.
Thank you, Professor Puan, for your profoundly insightful lecture. In the context of investment arbitration, where jurisdiction is rooted not in a single contract but in a network of treaty-based consents, how should tribunals approach requests for consolidation, joinder, or intervention involving multiple investors, related corporate structures, or parallel treaty claims arising from the same state measure? In other words, to what extent can tribunals rely on procedural discretion to manage these complex multi-party dynamics without overstepping the limits of treaty consent?
That's a great question, and it could provoke another lecture. It's a different topic than what we've been discussing. Rather than international commercial arbitration involving contractual disputes, it raises the question of investment arbitration, which depends, instead of the New York Convention, on either the ICSID Convention or multiple bilateral investment treaties. In the interest of trying to be concise on this, I think the opportunities for both consolidation and joinder and intervention in investment arbitration are significantly more limited than they are in international commercial arbitration. The reason for that is that, as your question foresees, many claims are brought under different bilateral investment treaties, which in turn would have different arbitral mechanisms provided for in them. And then, by analogy to the international commercial context, if you have one bit that provides for ICSID arbitration and another bit that provides for ICC or Stockholm Chamber of Commerce arbitration, there's no way you're going to be able to consolidate those different arbitrations. Also, I suspect, although we don't have time to discuss it in detail, there would be provisions in the different bilateral investment treaties that would make it difficult, in fact, to consolidate arbitrations under those different bilateral investment treaties, even if they provided for the same arbitration mechanism or a compatible arbitration mechanism. It's possible, I think, if you have multiple claims under the same bit involving the same parties, that the arbitrations could be consolidated. I think you would need to go to the institutional rules that the bit provided for arbitration under. That means either the ICSID Convention, ICSID arbitration rules framework, or alternatively, if it's ICC or UNCITRAL, and see what is permitted there. As we've seen, though, the UNCITRAL rules don't really have an effective means of consolidation, and the ICSID rules, although recently amended, don't provide many avenues. So I think that is a topic that Working Group 3 in UNCITRAL could usefully explore, as opposed perhaps to some of the other things that they're doing. And it's a very worthwhile topic, perhaps for another lecture.
Perhaps. Thank you so much, Professor
Thank you very much,
Gerborn.
Professor.
Thank you so much, Professor Gerborn. There is 195 person who got inspired by these wonderful presentations. So in conclusion, a piece of advice on how to start the provision or how to get your first case to inspire these audience even further.
Your first case as counsel, which is what I usually do, or as arbitrator?
As an arbitrator.
So getting your first case as an arbitrator is challenging, especially for younger practitioners. It's a little bit like, what kind of doctor do you want to go to for surgery? Do you want to go to a doctor who's doing her first operation, or would you rather go to a doctor who's operated on this kind of problem dozens and dozens of times? I think we mostly would choose the latter, and that's the same challenge that young arbitrators face. I think there are two main avenues coupled with a third possibility. One avenue is through arbitral institutions who, for small value cases, often look to younger practitioners, both because the fees that would be paid are lower and therefore more experienced arbitrators perhaps won't be so interested or willing to accept appointment, or if they do, perhaps don't devote the same time and attention that a young lawyer would. And so going to arbitral institutions, impressing them with your ability, your interest, your diligence, and your interest in doing either small value cases or emergency arbitrations is a real possibility. A second possibility is co-arbitrator appointments. And there I would urge reaching out to colleagues, friends at peer law firms and letting them know that you have experience in arbitration and that you're excited, interested in sitting as a co-arbitrator, even in very small value cases, or even in cases that they think are very likely to settle quite promptly. It's important to get that first appointment under your belt, because it's much better if somebody in the future asks you, well, have you ever sat as an arbitrator before? It's better to say, sure, the case settled promptly, but yes, I've sat, than to say no. This is my first time. A final suggestion is to prepare yourself for both of those avenues. Insofar as you can, sit as secretary, act as secretary for a more experienced lawyer who is himself sitting as an arbitrator. If you serve as a secretary, you participate. Perhaps you don't participate, but you're part of the participation in all of the deliberations of the tribunal. You see how the award is drafted. You see how the tribunal conducts the hearing, and you can therefore, with both the institution, but also somebody who asks you if you've sat as an arbitrator, you can say, well, I've sat once and I've been a secretary 5 times, or I've been a secretary several times. And that gives people assurance, and it gives clients assurance that you'll have some knowledge of what it is you're doing.
A huge thank to you, Professor Garibon. Thank you so much for your dedication and your time and effort. I know how incredibly busy you are. Thank you for your time. You inspired us even further. I'm speechless at this moment because you inspired me personally. So thank you very, very much. And I will leave the final remarks to Dean of College of Law, Dr. Hans.
Professor, thank you for your esteemed participation and the depth of knowledge you shared with us. Your contribution is sincerely valued and deeply appreciated. I would be my privilege to meet you in person very soon. Thank you so much.
Thank you, Paul, and thank everybody in the audience as well as Hatem and Dr. Gansa. Thank you for all your messages. This was a great pleasure, and we should do it again sometime.
We will definitely.
Thank you
Have a
so
wonderful Christmas, Professor.
Thank you all. Happy holidays.
Thank you.
Happy holiday. Thank you.